Okay, so today we're going to be talking about the digital legal requirements, a guide to keeping yourself legal while marketing, copyright compliance, but also keeping yourself professional. Again, if you didn't meet me last time, I'm David Lowbridge. I'm an online marketing consultant, strategist, and copywriter. I've worked in the industry for 12 years, and I've got a degree and master's in business from the University of Sheffield. I've been working with this kind of thing for many, many years. I've seen all the mistakes, all the legal loopholes, and some of the changes that have happened, which can catch businesses out. We're going to be going through quite a lot today. It's going to be a lot of information. If you've got any questions, please feel free to ask them. I've got a section at the end for us to go through things again. We will be covering your website and blogging, social media, email marketing, the data, holding data, and RSS feeds. So we're going to start with the website and blogging rules. So there are numerous rules which are global in most places. Different countries have different laws, but they all pretty much say the same thing, sometimes with a little slight variance on it. What we tend to do is ensure that we're following the most strictest version. Therefore, you're always going to be compliant no matter where the person is that's visiting your website. So for this, your website must include a privacy policy and cookie policy. There is a little bit of controversy on this, and that is while I was actually writing this presentation, the analysis from the latest Google update came in, and they're actually penalizing people for having a privacy policy on their homepage now. So how you have the privacy policy is up in the air at the moment of how you link to it and how people can see it. But apparently now, if you have a privacy policy clearly on your homepage, it will get you ranked down lower, but you still legally must have it. You've got to have contact details, including a physical address, visible on your website. It doesn't have to be on the homepage. It can be on a contact page, or it can be in the footer, but it must be somewhere on there. The next one's a rather interesting one, is websites should be made for audio only users. So people who are struggling to read pages, those with poor eyesight or can't see text very well on screens, they've got to be able to hear an audio only. Now, I'm not entirely sure how this goes online because a lot of websites don't have this. I think there's tools which they can use, and I think what it's basically saying is that you can't, from what I've spoken to people about, is that you can't have text on an image, and that's the only thing that you have on your website. So you've got to actually have written text so tools can pick it up and speak what's on your website to the user. And I think that covers you. The next one is not a legal requirement, but it's highly recommended by most governments, is that includes a terms of use and copyright notice on your website. So that really should go with the pages of the privacy policy and the cookie policy, but it is another page. The next three are mostly for blogging, but can be for any website. And that's any money, gift, exchange received for content should be made public. So we talked about in the last one about doing reviews for companies, doing affiliate marketing. If you receive any money or gift for doing that, you've actually got to publicly announce that that is what happened, is that someone gave you the product or someone gave you some money to actually do the review. Any money generated by affiliate marketing should be announced. So if you do any affiliate marketing, you've got to tell the reader that that is how you're linking, is that you're using affiliate links, and you will get some income from it. And the final one, which is the biggest one, is you cannot use material from a third-party website or hard copy without the permission of a content owner. Now, there are several examples of a copyright infringement of this, and it's really important to kind of understand it, because so many websites and bloggers actually fall into this trap every year. And I've had people who have come to me and said, oh yeah, I took this picture and now I'm being sued by the photographer for it. Is that right? And one of these is using an image that you don't have permission for. If you don't have permission to use an image, you really can't have it on your website at all. Copying text from another website is exactly the same thing. You can't just go and copy a load of text from, say, a news website and then plug it onto your website if you haven't got permission to do that. Again, this is very similar. The next one's very similar to images. It's using graphics or illustrations produced by a third party without their permission. So things like infographics is a very common one. If you don't have permission to use that on your website, don't copy it. And then the next one is distributing content without the original owner's permission. So this is taking any content from it. So it could be a social media post that they've got published on their website and then publishing it on your website again or in your blog. Or it could be that they've done some research and then you copy that research and publish it in your own words on your website. And that's really what we're talking about there. And these are the four main things that are really covered on the copyright infringement. Now, there's a lot of excuses which are used by website owners when they do make these infringements. And these do not protect you. You cannot say it was on the internet or in the public domain. It's just not a good protection. It's like saying you took a book out of the library and you copied the book and then released it yourself. You know, the book is in the public domain, it's in the library, people can read it, people can borrow it. It's the same thing. You can't do that. You can't take something off the internet, off another web page, off social media, and use it on yours. You can't say that you've made changes, you know, any color, size, rotation, anything like that. If it's come from the original, if the image is still originally from someone else, any changes are still apply that it's their content. You only use part of the protected work. Again, if someone has a whole blog post and you copy a paragraph or say you took half an image, that doesn't protect you. It's still part of the original work. The next one is one which people like to think they get away with, where they put a disclaimer that the content is not theirs originally. You could put that on your website. It still doesn't protect you. You still have to have permission, even if you acknowledge the owner. And that's the same with the next point, you know, you're acknowledging the original owner. There is no commercial purpose for the image. A lot of the times which people are getting sued for the image on copyright, there's still no, it's not commercially used. It's just used as a interesting point on a website or decoration. It's just there for the purpose of making a page look interesting, and they're not selling it. It still counts. Next one's an interesting one that's coming up more now than it has done in the past, and that's AI wrote or generated the content. So a lot of companies now are using AI in their production, and they tell the AI to write an article, but there's probably a fair few companies that are writing the same kind of articles. And if the AI produces two very similar or even the same article for two people and they both publish it, there is a little bit of a legal quagmire about who actually owns that, and even the AI company could actually say that they own it. So there's a little bit of a question mark about AI there. And then the last one is the image has been bought for another website, but you've published it on a second website. So sometimes from like Adobe Stock, you can buy an image if you buy it for websites, say example.com, but then you have a second website, you can't transfer that image over to the next website unless you've also bought the rights for that website. So you have to be careful on which website you're buying the rights for, make sure that you've got the rights for every single image or every piece of content that you're covering. How do we prevent breaking these rules? Very, very simple. Check your website has all the legal information, all those legal pages that we talked about on them. Use content that you've developed yourself. So that's about creating images, creating the text, no AI, no copying and pasting from any other websites. If you need images, you can use sites like Pixabay, Free Images, or Unsplash, or you can create them yourself. If you do purchase an image, ensure you keep the documents of the purchase, because sometimes what happens is that there aren't very good records. A photographer might not have good records. You've bought it legitimately off them, you put it on your website, but then they come to you and say, oh no, I didn't give you permission. Do keep those documents so you can prove it. and ensure you understand any licensing agreements. So sometimes when you buy or when you get content from someone, say like Pixabay or Free Images, there may be some licensing agreements. So you can only have the image for the first 10,000 people to visit your website. That is a license restriction. Or you can only show it to people in a certain country or a certain region. You have to understand those licensing agreements, because if they then find that you've breached them, then you can be liable for the copyright infringement on that.